morning, everyone. The open meeting of the Federal Election Commission for Thursday, May 19, 2016 will come to order. Before we get started with the agenda items, we need a motion for some submitted documents which have come in. Vice Chairman Walther is joining us remotely. And Mr. Vice Chairman, do you have a motion with respect to those late submitted documents?
Yes, I do, Mr. Chairman. I move to suspend the rules on the timely submission of agenda documents in order to consider the following late submitted documents. For agenda document 1612A1, proposed amendments to the draft final rule and explanation and justification for technical amendments to 2015 CFR. For agenda document 1613C, proposed consensus statement of policy regarding the public disclosure of certain documents. And for agenda document 1554B, I move the Commission add the agenda consideration of Reg 2014-01 outline of draft NPRM implementing party segregated accounts, and that the Commission determine pursuant to 11 CFR 2.7D that the business so requires and no earlier public announcement was possible.
We have a motion on the table. Is there any discussion on that motion? If none, all those in favor indicate by saying aye.
Aye.
Any opposed? Any opposed? Madam Secretary, that motion passes 6-0. First item on the agenda is the correction and approval of minutes for the meetings held on April 15th, 2016 and April 28th, 2016. Mr. Vice Chairman, do we have a motion?
Mr. Chairman, I move to approve the minutes for the meetings of April 14th and April 28th, 2016 in the agenda document number 1620A and agenda document number 1621A.
Is there any discussion on that motion? If not, all those in favor indicate by saying aye. Aye.
Aye.
Aye.
Any opposed? Madam Secretary, that motion passes by a vote of 6-0. Next item on the agenda, item 2, is Draft Advisory Opinion 2016-04, submitted by Grand Trunk Western Railroad Company and Illinois Central Railroad Company Political Action Committee. From what I understand, do we have Mr. Barron on the phone?
Good morning, you do.
Okay, good morning to you, Mr. Barron. Thank you for joining us. We have a presentation from the Office of General Counsel, Esther Jory and Nevin Stepanovic from the Office of General Counsel. Good morning to the both of you, and when you're ready, please proceed.
Thank you, Chairman Peterson. Good morning, Commissioners. Before you is Agenda Document 16-19-A, a draft advisory opinion in response to a request from Grand Trunk Western Railroad, Illinois Central Railroad PAC. The requester is a separate segregated fund of two subsidiary corporations of the parent Canadian National Railway Company. Canadian National Railway and its subsidiaries collectively operate under the brand CN. The requester asks whether it may use CN in its abbreviated name. The draft concludes that the requester may use CN in its abbreviated name because the brand name would provide the public with adequate notice as to the identity and sponsorship of the requester. We did not receive any comments on the request or on the draft. Thank you. I would be happy to address any questions that you may have.
Thank you for that presentation, Ms. Jory. Do we have any questions for council or any discussion on the draft? Hearing none, do we have a motion? I'll just state my position. This is, I think, a pretty straightforward draft. I believe that the proposal that set forth by requester as to how they would like to name their PAC is perfectly consistent with past advisory opinions on naming, and I think they present us with information that I think that was necessary in order to reach the conclusions that are found in this draft, and I'll be happy to support it at the appropriate time. Commissioner Goodwin.
Let me ask Mrs. Jory, was this requester in? Did we issue an advisory opinion to this requester in the last year or two?
Yes, we did.
What was the subject of that advisory opinion?
I can answer that question if anyone needs me to.
Sure. Why don't you?
It was a request that dealt with a situation where, under the rules, where you can go ahead and the corporate sponsor can make contributions to charities. Yes. As a match for the solicitations, as a match for donations to the PAC. and the question was whether a Canadian charity could be the recipient of that charitable contribution.
And Ms. Jory, do you remember, was that a 6-0? The commission issued an advisory opinion by a vote of 6-0?
It did issue an advisory opinion. I don't remember what the vote, I don't know what the vote was.
Okay. Thank you very much.
Mr. Nodi, were you? Oh, I saw you reaching for the microphone. I didn't know if you were going to
Sorry, I was
supply us
just-
with some information.
I was pulling up the vote, sir. It was 6-0 in AO 2015-02.
Okay. Thank you. Any further discussion? Commissioner Weintraub.
Thank you, Mr. Chairman. I'm not going to be able to support this request. I don't fault council for their analysis, which I think is consistent with earlier AOs that the commission issued, but we haven't really looked at this situation post Citizens United. The factual predicate of this is a little bit concerning to me. We have a subsidiary that is so thoroughly integrated with the foreign parent that in fact they want to name their U.S. PAC Canadian National PAC. I think this is an area that requires further policy consideration, and the whole question of foreign parents of U.S. subsidiaries is obviously one that I've been concerned about recently, so I'm not going to be able to support the draft today.
Commissioner Goodman.
Well, let me ask the Office of General Counsel, who may participate in this political action committee under current rules of foreign corporations and domestic subsidiaries? What are the extant rules regarding who may participate financially by giving contributions to this PAC, and who can participate in making the decisions for this political action committee?
Currently, the restricted class of the Political Action Committee separate segregated fund can make contributions to it. They have to be U.S. Citizens or green card holders. And there are several advisory opinions where the commission has addressed SSFs that are connected, their connected organization is a domestic subsidiary of a foreign parent, and those AOs have sort of given some limitations on who can participate in the decision making. We didn't fully flesh that out for this advisory opinion, so I can't give you all of the parameters that are set out in those advisory.
No, I just wanted to refresh my recollection that we do have a body of law regarding political action committees, which are associations of American citizens who participate in the political process, and their U.S. domestic subsidiary, their employer, a U.S. company that may be owned by a foreign company, can sponsor that political action committee. If I recall, using U.S. domestic revenues, and Americans have to make the decisions for the political action committee.
Yes.
And that's been the law for decades, right?
Yes, it's been a while. It is, as I said, in other AOs going back. I don't remember how far back, but yes.
Okay. So at the end of the day, the association here is constituted of the PAC, the people who give money to it, who make decisions for it, are American citizens. So this is an association of American citizens, is it not?
Well, again, you know, there are regulations that limit who can give money to the SSF based on their citizenship. As far as who's making decisions for the PAC, I can't answer that because we didn't ask. In other advisory opinions where that's been an issue, they've asked more questions and, you know.
Assuming they comply with the law, the extant law, only American citizens can make decisions for this political action committee. Am I right about that? That has been the law for decades, is that only American citizens can make the political decisions for the political action committee.
Yes, it's generally the case.
Oh,
Yes.
okay. So we're dealing with a political action committee constituted of American citizens who want to participate in our democratic affairs. This association of American citizens obtained an advisory opinion from this commission by a vote of 6-0 about a year ago. So I would just ask Commissioner Weintraub, what circumstances have changed.
Commissioner Goodman, this issue was not at all in our advisory opinion. We were just, and honestly, it wasn't part of the analysis. There was no back and forth on the foreign ownership. It was just a question about whether they could give money to a foreign charity. So it just raised an entirely different question. If a foreign company hired a bunch of American citizens and they wanted to form a PAC as part of a foreign company, we would say no. That's pretty plain law also. So this question goes to the issue of how much control the foreign parent has over the domestic subsidiary, and this is an issue that I have raised before, that I am concerned about, the connection between foreign parents and U.S. subsidiaries and their participation in U.S. elections. Obviously, these American citizens are free to make any contributions they want in American elections. They are free to form a PAC if they want to, separate from their corporation. The only question is whether they can do this as part of a corporation that is wholly owned by a foreign parent and is so connected with that foreign parent that they feel that it would be more honest to actually put that in the name of the PAC, that it's a Canadian company. So, I think this is a subject that requires more discussion at the commission and more policy development. I understand you don't agree with me, but I'm
Yes.
not going to be able to support it.
But if I may, Mr. Chairman,
Commissioner Goodman.
but what you're suggesting is a different treatment of these American citizens than the treatment given to all American employees of U.S. domestic subsidiaries over decades. So you're suggesting a change in the law here in the treatment of these American citizens who've come to us and requested. Now, if you need more information, perhaps, to give them an advisory opinion, perhaps the requester, we do this quite often where the Office of General Counsel takes questions back after colloquies here, and maybe they would supply you more information. But this Political Action Committee has been in existence since probably the late 1970s, early 1980s. And there's never, under extant law, they've complied with extant law. There's never been a question. And fundamentally, when this Political Action Committee is requesting guidance from this commission over how it conducts its political affairs, it is an association of American citizens who are participating under the umbrella of a Political Action Committee that is sponsored by their employer. And what I hear you saying, at least this is how I interpret it, is I'm not going to give these American citizens and this American political association the advisory opinion that it is entitled to under law by this commission, because I have other concerns about foreign companies that isn't implicated in here in just how they name their American association. And, I drive by, I remember this issue came up 2 years ago in an advisory opinion requested by Yamaha USA, where Yamaha USA, the American subsidiary of a foreign corporation, wanted to know if it could include in its restricted class good, red-blooded American citizens who run the Yamaha dealers around America. And ever since that, I drive by Jarman's Motorcycles in Charlottesville, Virginia, and they have a sign up, locally owned and operated since 1959 by good, red-blooded American citizens. And they wanted to know if Billy Bob Yamaha could be selected as part of their restricted class. And so I don't want to discriminate against the good American citizens who work for this company and want to form a political action committee under the umbrella of their American company employer just because the company they work for happens to be owned by a foreign company. And so I think these American citizens are entitled to an advisory opinion on the merits of their request.
Commissioner Weintraub.
Well, Commissioner, you are determined to put this in the most contentious fashion possible. These good American red-blooded citizens, we can't discriminate against good red-blooded American citizens. The larger issue isn't implicated. You think the larger issue of whether domestic subsidiaries that are fully owned by foreign parents, you think that their participation in the American political system is not implicated by this request, and I disagree with you. And we can continue to go back and forth about that, but I'm going to continue to disagree with you. So, sorry, I think this issue raises a broader issue that requires more study here at the Commission.
And, Mr. Chairman, I'll close with,
Commissioner Goodson.
I believe that broader issue has been decided and has been settled through decades of advisory opinions on how we insulated the American political activity of these American employees from the activities of a foreign company that might own their American subsidiary. And if you want to propose changes to that law, which I understand you may want to do, then you should do that. You should propose changes to that law. But I wouldn't, in the meantime, deny these American citizens a right to an advisory opinion under existing law that they are entitled to.
Commissioner Weintraub.
And my only response to that is that I think that Citizens United changed the entire legal framework for how we look at corporations and their participation in the American political system, and caused me to reconsider a lot of what seemed okay 20 years ago may raise new issues today. And again, I understand you don't agree with that. You don't think those larger issues are implicated, but I do.
Well, Mr. Chairman, just one more. Just recently, you voted, along with 5 other commissioners, to punish an American candidate who owned a foreign corporation for using assets of that foreign corporation in connection with his campaign in America. Wholly owned company in another country. Hasn't been made public yet, so I won't mention the name, but I believe probably the confidentiality doesn't apply anymore. And you didn't raise any of those issues there where you wanted to punish somebody, even though the foreign company was wholly owned by an American citizen. You had no qualms about what the law was in that case. All of a sudden, because there is a foreign owner of an American subsidiary, you think that the law has changed by Citizens United. Where was that argument when we voted to punish an American citizen who ran for Congress and used assets from a foreign company?
Commissioner Hunter, and then
Did you want to?
Commissioner Weintraub.
No, I'm not going to debate the merits of a matter that hasn't been made public with you here at a public meeting.
Commissioner Hunter.
And I was just wondering, sort of along these same lines, what if you had said earlier in the discussion that the people who work for this company can contribute on their own? And then I think you said they can get together and form their own organization and contribute that way. Well, of course, they can do that, and I think I agree with my colleagues on this side of the table that they should also be able to, under clear precedential decisions here, to also contribute through their American-owned PAC and company. But what if one of these employees in the American subsidiary, gets its paycheck directly from the Canadian company, even though the person is an American citizen, but his paycheck, let's just assume, I don't know if that's the facts here at all, but let's assume his paycheck comes from a Canadian company. He puts it in his bank account. Can he then write a contribution to Hillary Clinton? Under your new view of the law after Citizens United, I mean, it's Canadian money.
Commissioner Weintraub.
I'm not going to debate hypotheticals with you. My off-the-cuff reaction is that that's probably fine, but I, would want to give it some more thought. But you said it's an American-owned company, and it's not an American-owned company. It's a foreign-owned company. That much we know.
It's a foreign parent, but they have a U.S. subsidiary. I mean,
Yes, but it is owned by the foreign parent. That's what makes it the foreign parent.
Okay, so you really want to revisit the whole, that's going to, obviously, that new view of the law is going to impact many, many corporations in this country, and I don't think that that's warranted in any way by the Citizens United. And I'm trying to recall the New York Times op-ed that you wrote a few weeks ago now, I think it was.
End of March.
And it seemed like, my memory's fuzzy, but it seemed like my hypo was implicated by your by your piece. That if somebody's getting all of their money from a foreign source, then it could be problematic, is my recollection. And then also, if a group of people decided to form their own organization and contribute, run an independent expenditure supporting Hillary Clinton, I wonder if that would be problematic. It might be problematic if they're all rich white guys, but you had said on one of your most recent speeches that the problem is that all the super PACs are run by white, I think you said white rich guys?
I'm pretty sure I did not say that the problem is that they are run by rich white guys.
What did you say?
Well, I don't know. I don't know what you're referring to. You're taking some vague recollection of something that I supposedly said at some point. It is certainly true that the donor class is disproportionately white and male.
I'm not sure. There's some new reports out that call that hypothesis into question, or at least suggest that there's a lot more women and minorities
There are more
participating.
women participating, but I think it is still largely white men who make the donor.
I'm not sure how that is actually relevant to
Well, you brought it up.
No,
You tell
but
me
no,
why you
I brought it up because you brought it up, and I don't know. The reason I brought it up is because the commissioner on this agency has been out there in the public using that as an issue. So I bring it up to ask you what your underlying reason for bringing it up is. I don't think the Constitution, decides who has the right to speak based on, whether what their ethnic background is, or their racial background is, or their bank account is, thankfully. So I'm just concerned because you suggest, first of all, this can't happen under extant law, but then we're not sure if the individual who gets paid by a foreign corporation can actually contribute to Hillary Clinton. And if a group of people get together and form a super PAC and spend money independently, that could be a problem too, because some people want to overturn Citizens United. So if they organize as a corporation, I don't know, maybe they can't do that.
Corporations cannot make contributions to candidates.
No, I
I'm
said
pretty
run
sure
an
about
independent expenditure.
I'd ask Commissioner
Commissioner
Weintraub,
Goodman.
would you consider adding a sentence to this draft that reflects that, based on what Ms. Yori says, that this company, that this advisory opinion assumes that this company and these American citizens will comply or are in compliance with all other legal rules for the operation of American PACs sponsored by American subsidiaries of foreign corporations? In other words, we would put a sentence in that just assumes they're in compliance with the existing rules of law.
Commissioners, I understand you don't like the fact that I'm not going to vote yes, but you're just prolonging the argument here.
No, I was trying to address your concern. There is a body of law that has been developed over decades, and assuming that they are in compliance with all of those, can't we give these American citizens the advisory opinion that they're entitled to?
Well, you say they're entitled to it. If I agreed with you that they were entitled to this advisory opinion, then I would vote for it.
I just want to be clear of my understanding of your position. You want to change the law. There is a body of existing law that regulates this U.S. domestic subsidiary and the American citizens who work for it. And I am assuming that these American citizens who are associating under the umbrella of this political action committee and have been for decades, have been in compliance with those existing rules. And what I understand you saying is you will not grant them an advisory opinion here because effectively you want to change the existing rules. You want the commission to consider changing the existing rules. And that may be fair. By the way, that you may want to change the existing rules is a fair position for any commissioner here.
Thank you.
But these citizens are playing by the rules that have been in existence for decades. And so my position is these American citizens are entitled to an advisory opinion that they've requested unless and until the commission does change its rules. And so I just want to be clear about why you're voting no Is it because you want to change the rules?
I believe that Citizens United caused a sea change in how we have to view corporate spending and corporate subsidies of political spending in this country. And it is long overdue. And I am not prepared today to just continue along the line of precedence that was adopted pre-Citizens United. And let me just say, there was a lot of stuff said before that did not strike me as particularly relevant to this opinion, but I think once you earn your paycheck, it's your money. So I don't think we need to cause concern out there about American citizens who earn money and might have a foreign employer. Once you put the money in your own pocket, you've earned that money, it's yours.
Well,
Commissioner Hunter.
thank you. I appreciate that clarification. Along those same lines, though, if somebody wants to give, same thing, their money that they earn maybe from a Canadian parent organization, it's their money that they're contributing to the PAC. It's the same thing.
But the question is it an American PAC? Is the American subsidiary, which is wholly owned by the foreign corporation? I mean, let's remember, we wouldn't if we didn't have a subsidiary in between, we wouldn't even be having this discussion. If Canadian National came in here and said, we want to set up a PAC from the parent corporation in the United States, we would say, well, of course you can't do that, you're a foreign corporation. Now, you feel comfortable that because they've set up a wholly owned domestic subsidiary, that's enough of a separation to warrant allowing the participation. And remember, there is still a subsidy from the corporation through the PAC. And I think that we need to take we've been ducking this question ever since Citizens United. And it's because the commission has ducked this question ever since Citizens United, I don't think that binds us to say, well, now we're just stuck with all of these old precedents that happened before Citizens United because nobody's been willing to reconsider them. We have to just keep adopting them over and over and over again.
Commissioner Hunter.
I just don't know that anybody who read Citizens United thinks that it affects at least this narrow issue of a PAC, wanting to contribute to candidates through, law that's been on the books for decades. And I don't think I need to point out to Mr. Barron that I don't know if he's going to get 4 votes for this or not, but he's certainly not going to get 6. Obviously he can rely on previous opinions because there are a lot of old AOs on the books that haven't been overturned, because of course you would need 4 votes to overturn those advisory opinions. So he would be well within his rights to rely on those old and good advisory opinions.
Are there any further comments?
I've got a comment.
Yes, Mr. Barron.
This is Steve Walther.
Oh, Steve, sorry about that.
Yeah. Can you hear me all right?
Over the phone line was indistinguishable.
Oh, okay.
Go ahead.
Can you hear me okay?
Yes.
I'm going to join Commissioner Weintraub on this. A couple of reasons. One, I think when Citizens United came down, I felt that there was a rather strong policy shift in campaign finance. And it doesn't mean that everything that existed before as policy should necessarily just automatically stay the same. I don't think that's the case, because things aren't the same. And when you see the flow of money coming in from corporations now for independent expenditures, there's a lot of reasons why we ought to look at the policies involved, and I think most people agree with that. We've tried to do that a number of times, and there was a proposal, the New Disclosure Act in Congress. It had a majority vote, but not enough to make it law. And we have a proposal that was made back in January 20th of 2011. We have a conference coming up, I guess, next month or 2 on these new issues. So I think, for me, I do think the opinion that was provided by the Office of General Counsel was well written. It did track old law. but I don't consider it necessarily the same. And I would say that I took the position of taking a look at my view and view of the system, view of my opinion, and because of Citizens United in another AO. And in this case, I think I want to take another look at it myself. I'm concerned about, the seepage of money coming through for new forms of entities and parents of entities and subsidiaries and affiliates of entities without taking another good look at what the law should be. So we have those conferences coming up. We have the old draft will be part of the conference. There's been a lot of new thinking since Citizens United came down. I think we ought to take a look at what we come up with and see how it goes.
Any further comments or discussion? Mr. Barron, are there any comments that you would like to make with respect to the discussion that's heretofore taken place?
Well, I'm just coming back to my letter of February 22nd. I just want to reemphasize that the requesters here are the Illinois Central Railroad Company Political Action Committee, Grand Trunk Western Railroad Company, Illinois Central Railroad Company Political Action Committee, or GTW-ICPAC, and that's how it's currently registered. It has been, as noted, a long time separate segregated fund. The U.S. corporate sponsors of the fund, as the registration indicates, is the Grand Trunk Western Railroad Company and Illinois Central Railroad Company. Again, two wholly owned, but U.S. subsidiaries of the Canadian National Railway Company. Both Grand Trunk and Illinois Central have their own separate corporate existence, their own employees. They own their own locomotives, rolling stock, and property, and submit all legal and regulatory filings in their own corporate name. So, that this advisory opinion is really meant to encourage, that what we're seeking is really meant to encourage transparency so that people know just who we really are. And as I said, CN is a brand name, and yes, it applies both to the Canadian parent, but also equally it applies to the U.S. subsidiaries as well. And our business cards, our locomotives all say CN on it. The corporate headquarters in Homewood, Illinois, south of Chicago, says CN on it. And so we really were simply trying to operate within an existing parameter of precedent. And as far as I can tell, even with Citizens United, nothing changed with regard to the regulatory scheme with regard to corporations and political contributions. Those laws that we've relied on and that this letter is based on have remained in effect for a number of decades. So we're hoping that the Commission looks favorably on our letter, but obviously we have to go ahead and defer to what the Commission says.
Commissioner Goodman.
Mr. Barron, Lee Goodman, can you just affirm for the Commission that that this Political Action Committee has been in existence for decades?
It was originally formed in 1977. I want to say at some point in the early 2000s, an additional sponsor came on, but the original Political Action Committee, I mean, it goes back before my time as an attorney, but I want to say it was started in the late 70s. And it was originally named, I want to say, the Grand Trunk Western Railroad Company PAC. And so it's that the name Grand Trunk has always been in the name of the PAC. But and I said at some point there was an added affiliated sponsor. That was Illinois Central Railroad Company, and I can't recall when that was added. But yeah, the PAC, I want to say, goes back to the 70s.
And do American citizens make decisions for the
Yes, they do.
Action Committee? And and are only American citizens allowed to contribute to this Political Action Committee?
That is absolutely correct. As American citizens, and also, I mean, that's governed by law. It's got to be American citizens, and also to the extent they're a green card holding resident of the United States as well.
Thank you.
Any further comments? Commissioner Hunter.
I'm just wondering, as a practical matter, if one of the suggestions that Mr. Barron has on page 2 of his request, number 3, is considering one of the acronyms abbreviation GTW-ICPAC, comma, a PAC for CN entities. I wonder if the PAC kept their regular, the same name that they already have, which is GTW-IC PAC, and then just tacked on the APAC for CN entities as their own kind of explanation. It seems to me that that doesn't change the official name of their PAC. They're just adding a little bit of an explanation to it, and that sort of thing I wouldn't think would be relevant and the kind of thing that you would need to ask the commission. I don't know if RAD or OGC or anybody would have a thought on that.
Mr. Brennan, correct me if I'm wrong, but I don't think they're actually asking about changing the official name of the PAC. It's just the name that they're going to operate under.
That is correct. There's no request to change the official name of the PAC.
Okay.
It's just, one of the, we're looking at an advisory opinion on the potential 3 acronyms or abbreviations.
Do we have anything further? Do we have a motion? Commissioner Hunter?
Mr. Chairman, I move to approve agenda document number 16-9-A, which is draft A, and the one that was made public a week or two ago.
Excuse me, I'm showing it's 1619A. Or is it 169A? I'm sorry.
Excuse me. Yeah, 16-19-A.
Okay.
Yep.
That's perhaps what the Commissioner Hunter said. I just didn't hear it that way.
Okay. So we have a motion on the table. Is there any discussion on that motion? If none, all those in favor indicate by saying aye. Aye.
Aye.
Aye.
Those opposed?
No.
No.
Madam Secretary, that motion fails by a vote of 3-3, with Commissioners Goodman, Hunter, and myself in favor, and Commissioners Ravel, Weintraub, and the Vice Chairman opposed. Mr. Barron, thank you for being part of this discussion. Sorry that we couldn't reach an agreement on it, but thank you for answering the questions and participating in this discussion.
Very good. I will go ahead and, if no further matters, I will go ahead and drop the line then.
Thank you.
Thank you.
We will turn next to item agenda number 3, which is the draft final rule and explanation and justification for technical amendments to 2015 CFR. We have Eugene Lynch and Evan Stepanovic from the Office of General Counsel. Mr. Lynch, I don't know if there has been a little bit of movement on this. I don't know if there's any presentation you need to give, but if there's any updates that you need to apprise us of, feel free to do so now.
We didn't have any updates. I know there was a new agenda document.
Okay.
I just have a question for
Commissioner
Office of General Counsel. Does Office of General Counsel have any objection to the substance in the proposed amendments? And does Office of General Counsel believe that they would accomplish the intended objective?
We do. We don't have any objections.
Thank you.
Okay. Do we have any discussion? Do we have a motion?
Mr. Chair,
Commissioner Goodman?
I'm trying to identify which was, I went blue with the amendment just so it would be on the public record. Madam Secretary, what document number should I move? I'll just move that.
I have the language for that, but I thought Commissioner Goodman should be the one to make a motion since it's...
I
was just going to move the document.
I think, and correct me if I'm wrong, I think you want to move
It changes.
16-12A as amended by
That's true.
the changes in your memo.
Yeah, and I'm just trying to identify what ended up, what is the identifier for that memo?
Your memo is 16-12-A-1.
A-1. Okay.
Correct.
Okay, Mr. Chairman, I move that the commission approve agenda document number 16-12-A as amended by agenda document number 16-12-A-1.
Is there any discussion on that motion?
And also authorize any technical conforming edits for Office of General Counsel that may show up in the process of that amendment.
All right, we have a motion on the table. All those in favor indicate by saying aye. Aye.
Aye.
Aye.
Aye.
Madam, any opposed? I think I heard 6 ayes, but Madam
Yes.
Secretary, that vote passes by, that motion passes by a unanimous vote of 6-0. Thank you, Mr. Lynch. The next item on the agenda, which is the proposed statement of policy regarding public disclosure of closed enforcement files, is going to be held over at the request of the Vice Chairman. However, there is a new agenda document that was submitted by Commissioner Weintraub, and I think she wanted to just make a couple of comments about that document.
Thank you, Mr. Chairman. First of all, I want to thank my colleagues, Commissioners Goodman and Ravel, for all the work that they've put into their proposals to expand the number of documents that we put on the, both the number and the kind of documents that we put on the public record. I think it's a worthwhile endeavor, and I think there are large areas of agreement. And what I have tried to do in order to help to move the ball forward is to try and take, to synthesize Commissioner Goodman's suggestions and Commissioner Ravel's suggestions with our old interim disclosure policy and try and put it all together into one document. So it would be easier for, I hope that I've identified areas of agreement. I think it's, possible that we'll need to tweak the language here and there. And I apologize for not getting it around to folks until yesterday. But the goal was to come up with a single policy and to replace the old interim policy with a permanent policy. I thought we were going to do, for years, I thought we were going to do rulemaking on this. I'm still open to doing a rulemaking on this. Our lawyers tell us we don't have to do a rulemaking on this, that we can do this as a policy. But I think that it's certainly time that we adopt a permanent policy and stop calling it an interim policy. It's been interim for over a decade. And I think it would be useful to the public and to anyone who wants to try and follow what we do around here to have it all in one place, the kind of documents that we are going to put on the public record. So this was an attempt to, as I said, synthesize what had already been put on the table with what we already had on the books and try and move the ball forward in a constructive direction. And I look forward to my colleagues' comments on, and as I said, it's not intended to be a final document. I assume that there will be little tweaks, but I look forward to my colleagues' comments on that.
Commissioner Ravel.
I'd just like to say that I really welcome the suggestion. I think it's a really good idea. All along, I've said, and my concern about these documents, these two discrete documents, is that we should have some kind of a broader, holistic approach rather than incrementally, depending on each person's view about what is important. Instead, it should be a meaningful policy that will help the agency go forward in terms of more robust disclosure. So I think this is a great idea, and I think it's really important that we have a permanent kind of a policy rather than having an interim policy. So I support this. I think it's really a good idea to do this.
Commissioner, I think we're on a constructive path. I still see a few areas of discrepancy, but they're very minor. And so I want to thank both Commissioner Ravel and Commissioner Weintraub for working with me on this, and I think we're moving in a constructive course here.
Then we'll plan on taking this up in the very near future as we have a chance to look at this and figure out where we can reach agreement with respect to our disclosure policy. Next item on the agenda is Reg 2014-01, outline of draft NPRM implementing party segregated accounts. This was put on at the request of Commissioner Weintraub. And I imagine you would like to make a comment or two on this.
I would indeed. Thank you, Mr. Chairman. This goes to the new accounts that were set up under what's known as the Cromnibus at the end of 2014. There's a lot of money being raised for these new accounts, so we read about it in the newspapers every day. And we had our lawyers take a very thorough look at this, and they came up with some good constructive suggestions, a detailed outline for how we could move forward with rulemaking. They did that in October of last year, and we discussed it last December. And I think there was supposed to be some plan of maybe the Regs Committee was going to try and move this forward, or something was supposed to happen. And I was pleased that when we had our recent conference in Florida, one of our regular regional conferences, that the chairman indicated his support for our doing a rulemaking on this topic. But the sad fact is that nothing is happening. Absolutely nothing has happened since we last talked about this in December. And I think something really needs to happen. We need to move forward. We need to direct council. They're just sitting waiting for direction from us. We need to direct them to start drafting a rulemaking document. And if people have different ideas of what should be in that rulemaking document, I'm sure council would be happy to hear it and would be happy to incorporate alternatives. But right now, we're not doing anything. There was an article in just this morning, although I put this on the agenda late yesterday before I even had a chance to read this article, but there's an excellent article in the Washington Post this morning in which one prominent Republican attorney says, I think both political parties will find many creative ways to use the quasi-soft money accounts to support their presidential candidates. We are in an environment in which there has been virtually no enforcement of the campaign finance laws. So it would arguably be political malpractice not to make maximum uses of these accounts. I think that we are long overdue for providing some guidance to all of the people who are out there trying to operate under this new law. And I just say to my colleagues, what the hell are we waiting for? I think we should direct our lawyers to start drafting an NPRM so that we can provide guidance to the party committees and to the donors and to everybody else out there about how they're supposed to move forward using these new accounts, which are apparently a huge fundraising vehicle. And, you know, it's going on out there, and we're sitting on our hands on the sidelines. And I think we should move.
Any questions, or not questions, but any further discussion? Commissioner Goodman?
No, go ahead.
I couldn't quite.
You can go first.
I have a practical question, a wholly practical question. I believe a rulemaking in this area could be quite constructive. I think it's obvious that we wouldn't change the rules on anybody in the middle of this election cycle. We couldn't even probably get the NPRM out and comment it in to change it. So we would probably be looking at something early next year, I think. So that's a practical concern, number one. The second is, while the Democratic National Committee and the Republican National Committee are underwater right now, organizing national conventions in a presidential year, I just think we should think about the timing of when we put this out for comment, because this is going to impact them. They're going to want to comment, and they are their resources are stretched right now. And so I think we ought to consider that as we work through the process of when are we going, since we're not going to change the rules between now and November, we ought to think about when we're going to impose this rulemaking burden on the parties to bring us comments.
Commissioner Ravel?
I'm not disagreeing that we may want to have some considerations about timing, but my concerns about just our activities in general, and we've talked about this, is a very important part of our role is to provide guidance to others. And yes, it's not going to probably impact this particular election, given the timing for rulemaking, but I think it's very important for this commission to move forward on rulemaking on matters that are of great significance. And this is one that we addressed, and I'm trying to go back, I haven't looked at the date that this was first
The memo was from
provided to us.
October.
Yeah, from October 2015. And I think we're remiss in not performing the function that's really important so that people can know how to comply with our laws. So I would like to at least have us ask the Office of General Counsel to begin to work on this matter, and we can make determinations about when we decide to go forward on it. I don't think that that's something that we need to talk about today necessarily, but I understand your concern. No, and I understand that, absolutely.
And I'll just add that, as I mentioned, as Commissioner Weintraub mentioned, I did say that I support rulemaking in this area. I think additional clarification with regard to the use of these units would be helpful to everyone. I agree with Commissioner Goodman about there are the practical realities of when would be the best time to launch this rulemaking in order to get the most useful comments from the party committees that they could provide in light of the burdens they have right now. And so I think that we'll obviously need to take those into account, but I think that hopefully we can figure out a way that we can figure out what's going to be the best schedule and the best way to move forward with respect to this. And then just one comment, we took this up late last year. I had some concerns about some of the language in the outlines. I think we would need to potentially. I think that there would need to be some tweaks in terms of the guidance that would be provided in this outline that we'd want to give to OGC in terms of what we'd want to see in an NPRM document. I think one thing in particular was the implications that this rulemaking would have on an earlier advisory opinion that we issued to the national party committees with respect to the funding of the conventions, and I think that there was some concerns as to that, and there were some others as well. But I think that in terms of a rulemaking, I think it's a good idea. I think it's the realities that we need to operate within. Obviously, we'll take those into account, and we'll need to look at and figure out a way where we can land on a document that we're all comfortable for supporting, that we could then give to OGC to give them the head start in terms of draft. Commissioner Weintraub.
So do we have consensus that we want to direct OGC to start drafting? I don't want past delay to become the excuse for further delay. And we're never going to finish a project if we never started. So can we get them started with the understanding that commissioners will be giving them feedback about alternatives that they want to see proposed in the final NPRM?
I'm not comfortable saying start drafting yet, because this was, it's been about 6 months since I last read this, so I can't even recall all the specifics of this document. And so I think that the most productive path for us as a commission is to give them a guidance document that's going to have the most likely ability to actually get 4 or more votes. So I would want to go through and make sure that whatever direction that this outline provides is going to have the greatest likelihood of success. So I wouldn't support. I couldn't give the green light right now, but I don't disagree that we don't want delay to become the mechanism by which we're operating.
Could we?
All due respect,
Mr. Chairman?
It's been sitting on everybody's desks since last October, and nobody has provided any guidance to OGC about what, other than what's in this document, they want to see in here. So if not today, then when?
Mr. Chairman?
Mr. Vice Chairman?
I can see where the votes are going to go today, but I think I just want to go on record that I think there's nothing lost by moving forward to have OGC start to look at this and to start putting a framework on it that might even produce a better discussion than looking at an outline and suggesting what it might be and trying to decide in advance what we really want to think they're going to draw up. I'd like to see them take a run at a draft. We can call it a rough draft, and then see, those generate other ideas and better ideas, and then maybe we'll see ourselves looking at another draft and And by that time, the election might be behind us, and we can, then focus with more speed and more put out a better product. My concern is that when the election's over, there's going to be a sense that wow, the election's over, and maybe we'll get started on this next year. But I don't think anything is lost by moving it, by just getting a draft going and asking OGC to just give us their best crack at it. They know pretty well what the issues are. They could give us a draft A and B if they want to, even to say we know there's considerations in two different points of view. Here's what we think you might want to look at for discussion. So I would hope that we could get consensus to authorize them to get started now.
Commissioner Goodman.
Look, as I said, I think it could be a constructive proposal. But I do recall from months ago, and by the way, I don't recall the Regulations Committee late last year meeting to even discuss this and develop it further. So you've brought it back on our radar screen. I do recall from the last time this came up in the fall of 2015 that I did have some deep substantive reservations about the outline and the legal paradigm presented in the Office of General Counsel's proposal to us. I think I recall I discussed some of those at a public meeting. One was the abrogation of the advisory opinions that we issued in 2014 to the Democratic National Committee and the Republican National Committee. And that I couldn't support this outline as is if it was going to propose an abrogation of those advisory opinions, because the rationale that the commission had chosen in those advisory opinions was not affected by the creation of the special accounts in the Omnibus Reconciliation Act. There are other substantive issues that I recall. I think that some of the categories and the silos for some of these accounts are far too narrow. And so I do think that the Office of General Counsel would benefit from further discussion with commissioners before it just takes off to draft something based on this outline. Now, whether we do that through the Regulations Committee, I know that the chair and the vice chair now constitute the Regulations Committee, or whether we have a broader process in interacting, I'm willing to identify all my substantive issues in the coming 2 months to Office of General Counsel and put those together. But I'm not comfortable setting them off to draft something now based on this outline where I know I have many substantive disagreements.
Commissioner Weintraub.
Let me suggest that it's always been my position on rulemakings that, this would be to begin the process. We're not talking about a final rule here. We're talking about a notice of proposed rulemaking, and I think that those documents should always include alternatives that reflect any idea that any commissioner wants to put forward on the topic. I think personally that it would be helpful, it would help commissioners identify exactly what alternative they want if they saw a beginning document, an early draft from OGC. But as I said, nothing has happened yet, other than political party committees going out with, in the vacuum that we have created and doing, I'm sure, the best they can. I know that both of the political party committees, the major political party committees, are well advised. They've got good lawyers. I'm sure they're doing the best they can. But I just think that we are abrogating our own duties to provide guidance on this new law, and we have to get started. I think that my own view is that OGC could start, and with the understanding they would be getting ongoing feedback from commissioners about other alternatives they wanted to see proposed. And I'm not predicting, I honestly haven't decided yet where I would land on any particular issue in here. I thought it was a very good starting point, the October memo. If you want more time at the front end to provide them with some, I don't see any downside to their starting drafting now. But if you want more time at the front end to give them some more feedback at the front end, I'm okay with that. But that's what we said we were going to do in December, and nothing has happened since. So I'm just putting everybody on notice that I'm going to keep bringing this up. I recognize the timing issues. I'm open to discussing the timing issues, but as I said, I don't think we should let past delay become the excuse for further delay. Otherwise, we're going to find ourselves next year just starting the project, and then people will put it aside for another few months, and then, oh my gosh, it's 2018 already, and we're in an election year. We can't do it now because we're back in the middle of an election year, and it will never get done. We have to just start.
Commissioner Goodman.
What is the evidence that the parties claim they don't have sufficient guidance today? I mean, if we think they're doing something really untoward, that would be a compelling reason to move very quickly. And the other is that the parties are complaining that they don't have the guidance that they need. That's a really compelling reason to move very fast. By the way, and I'm not suggesting that we abrogate our responsibility to provide guidance. I'm just saying, what is the compelling problem right now?
Well, it appears that our Office of General Counsel, based on the discussion here at the table today, has one view of what the law might mean, and not all commissioners share that view. So there appears to be some not complete agreement even of the people sitting at this table today as to what this law means. So if we're not sure what it means, then how do we expect that people out there have a perfect understanding of it?
Well, on the issue we just discussed, on whether to abrogate the convention committees established by advisory opinion,
Right.
there is no disagreement that there is an extant advisory opinion, that both national parties are relying on it, that this commission recognizes those committees. They file regular reports with the commission. They get RFAIs from the commission, and they are operating and reporting pursuant to the advisory opinion. Now, someone may want to change that law, so I don't say that's a disagreement in the law. I think that what Office of General Counsel was recommending was that we change extant law on the advisory opinion and change what is now well-settled practice by both national parties. So, listen, I'm willing to undertake this process. I guess I was just asking, I had a practical concern about the timing, and so I was adding a question that was, where is the problem out there? Do we think that they are abusing the accounts right now? Do we have reason to believe that the Democratic National Committee and the Republican National Committee are abusing these accounts in some way? I'm just not aware of a problem that compels us to act immediately, and yet I'm willing to begin working with Office of General Counsel.
You know, I'm not sure that's a
Ravel.
relevant question. Sorry, Mr.
Oh, no,
Chair.
no, not
Because
very relevant.
I don't think it's a
Just for people out
relevant
there.
question because we know that there are disagreements in some of these matters, maybe not the one that you're talking about, maybe that's very clear, but there are others where the law is not clear about the usage of some of the accounts, and there's potentially disagreements. But we've already acknowledged it's not going to impact this particular election. The question is, are we going to abrogate our responsibility? And I think we need to move forward. And what I would suggest, and I appreciate that you've got things that you would like to add, and you mentioned within the next 2 months, maybe we could set a date certain for everyone to provide their suggestions to council, and that we could then come back and have a discussion about it, set a date for us to discuss it at a meeting right now, so everybody is on notice that we could do that. What I worry about is the same thing that Commissioner Weintraub has mentioned, and that is that, and just by virtue, this is no, negative to any one side or anybody, but time gets away from us and it goes off the radar, and we don't then deal with matters that we really should be dealing with, and it would be good if we had some certainty about at least when we're going to come back and discuss it, and if we need more time, then we need more time.
Commissioner Hunter?
We may decide to go forward with this rulemaking, and we might have 6 votes to do so. But I take exception to the characterization that we may be abrogating our responsibility. There is no responsibility to write a rule on this issue. The Congress passed the law, was passed by Congress. In this time where it's hard to get these types of things through, Congress passed the law, and the party committees are doing their thing. As Commissioner Goodman suggests, I know of no evidence that they have any questions. We've never had an advisory opinion on this at all. The person that you quoted from the Washington Times, Mr. Rob Kellner, who I know and respect, I mean, you probably don't read the Washington Times, the Washington Post, great guy, but as far as I know, he doesn't represent the political parties. Maybe he does now, and I'm not aware of it, but I don't think he does. And so, again, I'm not aware of the parties running around scratching their heads saying, gee, I wish the FTC would do a reg on this. And so we don't have, and the law doesn't call for us, I don't believe, to do a regulation on it. As you know, sometimes when Congress passes the law, it requires the FEC to implement a regulation on that issue. As far as I know, as far as my recollection, there's nothing in this law that requires us to do a regulation. And I think the statutory provision in FECA is that the commission shall do regulations when necessary. And I don't see any evidence that it's necessary here. Going back to last year, I was on the regulations committee then, and I don't recall ever asking the Office of General Counsel to write this memo. I don't think we ever had a discussion about it. I received the memo, and I'm not saying that it was poorly written or anything like that, but I just don't recall anybody getting together and saying, write this memo. So I never thought it was necessary to begin with.
Mr. Chair, just one
Yes,
comment
Commissioner
about
Ravel.
that. What I meant by abrogating our responsibility was that we do have an obligation to provide rulemakings that will assist the community that relies on our guidance to be able to comply with the law. And I recall the last rulemaking we did, and we did it together, on Citizens United in the McCutcheon case. There was nothing in the court decision that said we had to do rules. There was no one who was coming before us saying, oh my God, we need guidance. Everybody sort of knew what the obligations were under the law with respect to compliance. But those of you on that side of the table thought that it was really important, as did I, that we provide that guidance to people. So this is not this is not saying, it's not partisan, it's not any of those things. It's just, I think, what our job is to do.
Commissioner Hunter.
I hear what you're saying. I think there's a bit of a difference between removing regulations that have been held unconstitutional by the United States Supreme Court. That seemed like a pretty reasonable thing to do.
Well,
Mr. Vice Chairman.
Thank you. The only thought I had is I sense a situation where if we're going to adopt a rulemaking, I guess it has, and I haven't held the statute, when we deem it necessary. But from the comments of these two commissioners, it looks to me that their opinion is we don't need it. If that's so, I mean, if it happens to be 3, then we ought to make it, we ought to forget about it and get on with business and not to go through the exercise. So that's my only thought. Unless we have a majority of commissioners that says that they think it's necessary that we do a rulemaking, we can decide that fairly quickly, and rather than the painful wait and then decide it sometime later. So that's just my thought. I happen to think that those are brand new areas, and probably people would like to have the guidance in reg form as opposed to no form. Just to make it easier on them. But I have to admit I haven't tried to divine any rules one way or the other on this. So maybe the consensus is even out in the field that we don't need it. But let's take a look at that and see. I mean, we can ask these people out there, and we shouldn't draft rules just for the party committees when the general public is involved, but certainly, if they're not interested, then we should be aware of their thinking in that regard.
Commissioner Weintraub.
Thank you, Mr. Chairman. I want to reiterate what I said before. You, at least, Mr. Chairman, have said publicly that you think that we ought to be doing this rulemaking. I hope you haven't changed your mind. I think it's ridiculous to suggest that there are no open questions under this law. I can think of several off the top of my head where there's probably wide disagreement at this table. Transfers between these accounts. Once the money comes into these accounts, can they then be transferred around for other purposes? And I like the way you, Commissioner Goodman, said, well, there's no question that that advisory opinion is still good law. I'm not convinced that that advisory opinion survives the statutory change that Congress made. It's not at all clear to me that Congress anticipated that in addition to the 3 accounts that they would set up, that there would be this other account. You talk about the well-settled practice of the party committees. This law's only been on the books since the end of 2014, I believe, so there can't be anything too well-settled going on out there. It just hasn't been around long enough. But in any event, I think there are questions out there, and I'm sure the party lawyers are out there doing their best to give their clients the best guidance they can, but you know, to some degree, they're making it up because we have been silent, and I think the law is not crystal clear. There are ambiguities, and we should resolve them. And we should do it sooner rather than later.
So let me make the suggestion that now that this has been kind of brought back off the back burner, that I'll go back and relook at the outline and I would hope that to do that soon and I'll obviously in consultation with colleagues figure out what modifications we might want to have to that outline and see if we can't do that within the next. Well, certainly starting the review right away, but maybe even having an ability to vote on it within the next month or two. So. But let's see how that process proceeds, and then we can, because I figured that, you know, if we can agree on an outline, then there will be a period of drafting that the OGC will have to go through, you know, so we really are looking more at late this year, early next year, but I think in terms of getting the ball moving, I think that the sooner the better is probably the wiser course. Commissioner Goodman.
Yeah, I just, I was impressed by Vice Chair Walther's comment that we first have to get over the threshold of whether to do it, and whether there's going to be a general consensus to do it. I don't have a strong opinion against it. I want to preface this with that comment, but I think that's an important question to ask. And then if so, what? And I know that in the substance that I saw, I have significant changes I'd like to make, and I also may want to add other party regulations as part of this party rulemaking that I proposed a year ago and that were not accepted. But I may, as long as we're addressing political parties, I may want to address other issues with regard to political parties.
It's going to become a Christmas tree.
Do we have anything further? If not, we will continue discussion on this matter, and look forward to discussing both in meeting and offline with my colleagues on this issue. That brings us to item 6, which is discussion of any management or administrative matters. We have Ms. Chacona subbing for Alec Palmer today, but do we have any such matters to discuss?
Mr. Chairman, there are none.
Hearing that there are none, this meeting is adjourned.